rules surrounding British nationality, eligibility requirements, and if your children can obtain it, it can be a very confusing minefield, difficult to navigate for the average person. This is one of the reasons there are so many immigration lawyers out there. When all said and done, it is possible to navigate your way through on your own, but without the right information, it can take years of frustration before maybe succeeding in the end. I have just succeeded in obtaining British citizenship for my 12-year-old daughter. It was a long journey, with lots of setbacks and frustrations along the way. And although everyone's situations vary from person to person, I would like to try and help those treading the long-worn path I have been down by sharing my learnings and understandings of mistakes to avoid and steps you should take. There are many types of British nationality, such as British citizenship, British overseas territory citizen, British overseas citizen, British subject, British national overseas, and British protected person. However, today we will be looking only at British citizen. As a British citizen, you can live and work in the UK free of any immigration controls. You can also get a UK passport. Within the nationality of being a British citizen, there are two types. British citizen otherwise than by descent. These are the majority of British citizens, and can pass on citizenship to children born anywhere in the world, meaning either inside or outside the UK. This leads to the other type of British citizen by descent. Normally, a British citizen otherwise than by descent can transmit citizenship down one generation to children born outside the UK. So what does this actually mean? A child born to a British citizen outside the UK will be a British citizen by descent. This means that any children they have in the future will only have a claim to British citizenship if they're born in the UK. And a child born in the UK would be a British citizen otherwise than by descent. If someone who is a British citizen by descent has a child born outside the UK, as a rule they have no automatic right to British citizenship. This, however, is not the end of the story, as there are situations where a child born outside the UK with no automatic claim to citizenship may be registered with the Home Office as a British citizen through a variety of paths. At this point, it may be a good time to clear up a few points. A person born in the UK before 1982 has a right to British citizenship, even if neither parent were British. The British Nationality Act 1981 amended this, so in order for a child born in the UK to have a valid claim to British citizenship otherwise than by descent would require at least one of the parents to be British. All of the above had dealt with children whose parents were married. Next, we will look at the situation where, for whatever reason, the British father of the child is not married to the child's mother, or the child's mother was married to someone other than the child's British biological father. With effect from the 1st of July 2006, children may acquire British citizenship automatically from an unmarried British father, or a British permanent resident if the child is born in the United Kingdom. Proof of paternity must be shown. Children born to unmarried British fathers before the 1st of July 2006 are not included in this provision. However, they can be registered as British citizens upon application to the Home Office, provided the child is aged under 18 and would have been British had the father been married to the mother. The agreement of the mother is needed. If the mother refuses, then the policy is for the Home Office to inquire of her reasons for refusal. If her reasons are deemed unreasonable, registration may still be granted. Also, the minor can apply in their own right on reaching the age of 17. As of the 6th of April 2015, a person over 18 years of age who was born out of wedlock before the 1st of July 2006 to a British father is entitled to register as a British citizen by descent under the Immigration Act 2014 using Form UKF. Such child must also meet character requirements, pay relevant processing fees, and attend a citizenship ceremony. However, if the applicant has a claim to register as a British citizen under other clauses of the British Nationality Act 1981, or has already acquired British citizenship after being legitimised, the application will be refused. If the mother was married to someone else other than the child's British biological father, the Home Office normally give the response that the husband of the mother is considered to be the child's legal father. This is not, however, the end of the road, as there are provisions for you to be able to prove paternity and pass on citizenship to the child. These include: you'll be eligible to apply for British citizenship if you would have become a British citizen automatically if your mother had been married to your natural biological father. You have never been a British citizen. And now, how someone missed out on British nationality. Before the 1st of July 2006, unmarried fathers were not allowed to pass on nationality. A child born outside the UK to an unmarried father before that date could not acquire British citizenship from him. By contrast, a married father could pass on British citizenship to a child born overseas. Up until 1983, this did not affect children born in the UK, as at the time being born in the UK was sufficient to become a British citizen. However, from 1983, a child born in the UK only became a British citizen if at the time of their birth one of their parents was a British citizen themselves or settled in the UK. Until the 1st of July 2006, an unmarried British citizen father or an unmarried settled father was not classed as a child's parent for nationality purposes. By contrast, the child would be a British citizen if their natural father was a married British citizen father or a married settled father. In addition, there are registration provisions which allow a child born from 1983 to register as a British citizen where their parent becomes a British citizen or settled after they are born. Until the 1st of July 2006, these registration provisions could not be used by a child whose unmarried father's status had changed. By contrast, the child would be able to register if it was the status of their married father which had changed in this way. If you could have applied if your parents had been married, you can apply using Form MN1. Who is eligible to register? You will generally be able to register if you were born outside the UK before the 1st of July 2006 and your unmarried father was born, naturalised or registered in the UK before you were born. If you were born inside the UK on or after the 1st of January 1983 and before the 1st of July 2006, and your unmarried father was born, naturalised or registered in the UK before you were born or was settled in the UK when you were born, if you were born before the 1st of July 2006 and your unmarried father became a British citizen or settled after you were born, but existing registration provisions cannot be used because your parents were not married, you can apply using Form MN1. If you were born after the 1st of July 2006, but you did not become a British citizen because your mother was married to someone other than your natural father, you can apply using Form UKF, provided you meet the following requirements. To apply under these provisions, you will need to prove your relationship with your natural father. To do this, you will have to provide evidence of paternity. If you can provide genuine and reliable documents, we will recognise a man as your father in the following circumstance. He is named as your father on a birth certificate issued within 1 year of the birth, or a DNA test shows he is your father, or a court has ruled that he is your father, or you can provide other evidence that is sufficient to establish paternity. The above case is the situation I found myself in, and it eventually took me over 12 years navigating the system before succeeding. I hope this has been of help, and if you have any questions, drop them in the comments. If I can answer them, I will. Remember, I am not an immigration lawyer. I am someone who over a long period of time has navigated my own way through a system that, to be honest, felt like it was stacked against me. My timeline is as follows. In 2011, my daughter was born outside the UK. Her mother is Filipino and was married to someone else, but separated for years before we met. As divorce does not exist in the Philippines, she is still technically married to him. In 2011, we registered the birth at the British consulate, but the certificate said we were married, which was not the case. In 2011, we applied for a passport for my daughter. The application was rejected as the passport office wanted a CNOMAR, or a certificate of no marriage, for my partner, which of course we could not provide. I wrote a letter to the passport office explaining my situation and received the reply that my partner is married to someone else and the husband is deemed to be the father in the eyes of the law. Therefore, my daughter has no claim to British citizenship. Between 2011 and 2015, I looked for ways to obtain citizenship without success. The Home Office gave no useful advice. I even applied for a visit visa with my daughter and my partner using their Filipino passports. The visit visas were both rejected. Basically, they said that they believed that they were economic migrants and would stay illegally in the UK. My daughter was 4 years old. I couldn't understand how they could possibly believe that she could be an economic migrant. Anyway, in 2015, I contacted my local MP in the UK, explained the situation, and he tried reaching out to the Home Office and the Immigration Minister for advice on how to proceed. 2017, still no progress. In November of that year, my mother passed away, having never met her only granddaughter. Following my mother's death, I became disillusioned and lost interest in continuing the attempts with the Home Office. Between then and 2020, lots happened that shifted the focus, such as the COVID pandemic, lockdowns, no air travel, etc. In 2021, I re-engaged with my MP and his caseworker team, and we continued looking for a way forward. 2022, again nothing happened. In 2023, I called the Home Office in London from abroad and spoke to someone who genuinely seemed to want to help for the first time. He went away to check, left me on hold, came back and advised me to apply using Form UKFM, a form that is titled Form UKFM, Application for Registration as a British Citizen by a person born on or after the 1st of July 2006 to a British father where the mother was married to someone other than the natural father. This seemed to perfectly fit my situation. The application was submitted in February. The time frame for completion was stated as being 6 months. After 8 months, we were advised that the application had been rejected due to the fact that I had not disclosed anywhere that the mother of my daughter was married to someone else at the time of my daughter's birth. I found this bizarre, as this is exactly the name of the form, plus there was nowhere in the guidance notes, and there was nowhere in the form itself to make such a declaration. In December 2023, I was then advised the law had changed and that I should submit another application using Form UKF. I completed this form following the guidance notes and in addition included a letter detailing my situation and the fact that by this point I'd been going round in circles for 12 years. Again, reaching out to my MP who followed up with the Home Office application team, they said they understood my frustration with the illogic of the previous rejection and would expedite the application. In January of 2024, I received a letter confirming that British citizenship had been granted. In April 2024, I received the certificate of registration as a British citizen from the Home Office. My next step, which should now be a formality, is to apply for a British passport for my daughter. Once this final step is completed, we will be able to travel to the UK, where my 12-year-old British daughter will be able to meet her older brother and other family members for the first time, as up until now she's not been able to travel to the UK. As a final note, if for whatever reason you hit a brick wall with the Home Office, do not give up. Even though I'm a British expat, I engaged my local MP in the UK to assist, guide and support me, and the help provided was invaluable. At one point people are generally not aware of is that the Home Office has a department dedicated to responding and updating MPs on their inquiries and requests. This is your silver bullet, and should only be used when you cannot see a way forward yourself. I hope my experience may help you and provide some guidance in your journey. Thank you for taking time out to watch this video. If you found it useful, please like and subscribe. Over time, we will be adding more content. Thank you.